Yes, sir. Please step right up in front of the microphone, and you're going to have 5 minutes to speak, and then your colleague will also have 5 minutes to speak. Yes, sir.
Good morning, Your Honor. May it please the court. The reason we are here is we believe there was abuse of discretion as per U.S. versus Roberts. There were significant factors that deserved weight, which was not allowed, and that was filing number 38 and 39 as per docket sheet. Number two, improper factors was accorded significant weight. That was the old section 18327, which was the only defense that the United Bank had. Number three, there was palpable errors in judgment where a bill of accounts was never given because accounting was never given. The issue was the controlling statute which governed the surplus was 24420, which is part of the foreclosure statute, and by that statute, parties are entitled to accounting as a matter of right. Secondly, the judge should have heard the evidence which was presented to her in a form of canceled checks, which were part of my filing. The second issue is the question of the foreclosure deed. The foreclosure deed is governed by section 183(6), and it is our contention that full consideration, it was not registered with full consideration, which included taxes.
Wouldn't you be able to raise these arguments, though, before the appeals court when your appeal is perfected?
Yes, but the evidence was thrown out, and the appeals court does not have to consider any evidence which is not been considered by the lower court judge.
Well, it needs to consider your argument that the lower court should have had that evidence before it.
Yes, it was thrown out by the docket. This is a violation of REBA, ethical consideration 1, and multiple rules, including the rules of this court, Canon 3.22, ABA Rule EC 1.5, and importantly, 18 U.S.C. 101 with its implications. Thirdly, this was just a property dispute, and I think we should have been given the right by the lower court for a jury trial. It was thrown out in summary judgment. This is a violation of Massachusetts Bill of Rights 15 and 29. And finally, the excess, which we don't know what the excess was applied to a UCC loan. The UCC loan was governed by a financial statement which does not constitute a mortgage under 183-106. The only right the United Bank had was a right to the fixtures and improvement, but they, after filing in approximately January, a UCC filing, perfecting the lien, they decided to wait along and try to get the surplus proceed from the foreclosure. And they convinced the judge that it constituted a foreclosure, constituted a mortgage in a sense, and they could reach that. It is important to know that I was not the property holder. I just had a mortgage which was satisfied completely with the proceeds, and there was in excess of $142,000 left, which was arbitrarily distributed between the bank and the closing attorney. The closing attorney, we enclosed checks which received $62,000 for doing this procedure. And my co-defendant will talk more about it.
All right.
Thank you.
Thank you, sir.
Chief Justice and Associate Justices, may it please the court. I'm Susan Manny, and I represent myself in this case. This case before this honorable court is an appeal from the ruling of Justice Spina denying relief pursuant to Superintendent's 211 Section 3. The question before this honorable court is whether the facts in the complaint and brief resulted in substantiative right violations of the petitioners. Massachusetts Declaration of Rights, Article 15 and Article 29 of the Massachusetts Constitution. The petitioners briefed the single justice with supporting material evidence that in the lower court, Judge Josephson did not allow and consider the opposition and response motions of Susan Manny and Manny George that were filed in response to the cross motion for summary judgment as it relates to GLC 93A violations. And it was docketed as the case docket sheet will show, addendum tab A, as paper number 38 and paper number 39. The case docket sheet will show that these motions were not allowed later to arrive at the Judge Josephson's memorandum of decision. The case docket sheet shows that at the hearing, the motions were in front of the justice, and the transcripts will show when I questioned the judge, do you have all the motions in front of you? The justice said, I do have all the motions in front of me, and I will consider all the motions that have been filed to this day, which included the paper number 38 and paper number 39, which were responses and opposition to the bank's cross motion for summary judgment. Later on, before the summary judgment ruling, the docket shows that she allowed paper number 30, she allowed paper number 34, she allowed paper number 37, not 38, and paper number 40. At the summary judgment stage, the judge had a duty, it was not her discretion, to allow all the material evidence and motions that were in front of her, to consider all the evidence that was presented to her, to arrive at her memorandum of decision. A quick overview of her memorandum of decision shows that she has not considered any of the deceptions and misrepresentations and unfair practices that were resorted to by United Bank.
Excuse me, but couldn't you say it's a reasonable inference that because of how she ruled in the case that she actually decided paper number 38 and that it may not have been written down, but it's obvious?
No, Justice, if you look at the memorandum of decision, she has only addressed the surplus, and she took it at face value that the bank stated that it is $99,132.10 at face value, and she had distributed the surplus 50-50, hoping that with our economic disabilities and problems, we would take the $50,000 and walk away. She has not addressed any of the official checks that were distributed by the bank on the 31st from the surplus proceeds. The loan posting sheet, which is addendum tab D. Tab D, Your Honor, clearly shows a loan posting sheet, which shows that on 7/21, the day of the foreclosure, the first mortgage of $378,889.26 was extinguished. $40,347.35, which is the second mortgage, was extinguished, and there was a surplus of $142,763.39. The bank issued on 7/31 5 official checks, of which $11,139.52 were for the attorney, the law firm who conducted the foreclosure, and $52,881.02 was also to the same law firm who conducted the foreclosure and who initiated this instant lawsuit in front of which was the Judge Josephson was the motion judge. A month later, after the surplus was distributed by the United Bank, there is a pattern, Your Honor, of unfair practices and deception that was resorted to by United Bank. I'm going to quickly go down. They filed the UCC claim on 2/28/2006. Instead of going after the accounts receivable from Manny George's business practice, they sat around until the house was foreclosed in July 21st, 2006. They did not make any attempt before that to go and collect the debt of Manny George from his business.
I'm sorry, I have to interrupt you. You see that blinking red light?
Yes,
Your
may I
time is
conclude, sir?
Yes, ma'am.
The briefs show that there was a pattern of unfair practices, including the taking of $22,000, omitting it from the foreclosed deed of the property. It should have been recorded at 562. They omitted the taxes, saying that it was owed and due, which was not the case. Later on, the town officials provided proof that a portion of the $22,000 which was owed and due, they said at foreclosure, was used by United Bank to pay for real estate taxes when they held title to the property. Recording the foreclosed deed, omitting $22,000 from the gross sale price of the property was gross misrepresentation on the part of United Bank, and the judge overlooked all these factors that were presented to her in paper 28 and paper 39, looked the other way to come to a decision which would favor United Bank, because she was not willing to give 93A violations against the bank. And my thing is, Judge, our due process was violated, our substantiative rights were violated. The bank to this day have not answered anything regarding the checks, the $22,000. They have just said, oh, Judge Josephson gave summary judgment, so now it's res judicata. And they have also not given us to this day an internal service form 1099, which shows the gross sale price from the foreclosure and the gross surplus from the foreclosure. To this day, the bank has not given us a form, has not sent us a form. We do not know what the gross sale price of the property was 4 years after the foreclosure occurred. And we claim that our rights were violated. We were treated differently because the bank felt, I believe they were above the law, and they had the enabler in the form of a justice who looked the other way. I thank you, sir.
All right.
Good morning, Your Honors. Assistant Attorney General Mary Ann Reynolds for Judge Josephson and Clerk Jekanowski. I'm willing to share my time with counsel for the bank, who is here, should you wish to hear him. And so I would ask for 8 minutes of the allotted 10, if that's okay.
Sure.
Thank you.
Well, can you speak to the point that I understood Ms. Manning was making about the various papers that she says the judge did not consider?
Footnote 3 of the judge's memorandum in order identifies all of the papers that were considered in her making her decision. I believe when you compare the items listed in that footnote 3 together with the items that are docketed and that have been referenced by the Mannies, that it is a complete list. if by some chance I'm wrong on that point, that's a fair issue for the Mannies to bring to the attention of any appeals, in any appeal that they would take from that judgment. But I do believe she did consider everything. And so the single justice in this case neither abused his discretion nor committed an error of law in denying their petition. The various claims that the petitioners have brought to your attention this morning are all issues that they could raise in the normal appellate process. And if they wish to be heard on those issues, they can be. This is not the forum for them to do so. They should raise those issues in their appeal. We brought that to the single justice's attention, and he agreed with our position. We think that the single justice should be affirmed. As to the sort of suggestions, although not well developed, but
the single justice said 211.3 was not the appropriate remedy. Is that right?
Yes.
And there is an appeal going forward in the appeals court.
There was an appeal filed, a notice of appeal filed by the petitioners in the appeals court. I understand that the bank also filed a notice of appeal, so there were cross appeals from the judgment. And it was docketed in the appeals court. But if I understand correctly, in the appeals court docket shows us, is that the appeal has not yet proceeded because the petitioners here have claimed that the record is not yet, the Superior Court record is not yet complete, so it was docketed prematurely. It's my understanding that, it's up to them at this point to, I believe there's a transcript issue. I think the transcript was mentioned here this morning in argument, so that they, once they get the transcript that they may need for their appeal, it can go forward. And so that's where they should, that's how they should proceed if they wish to be heard on these issues, to the extent that their papers suggest, and you heard no suggestion of this morning, but to the extent their papers suggest that there was any misconduct on behalf of either of my clients, such claims are wholly unsupported in the record. And as this court recently decided in the Watson v. Appeals Court decision, unsubstantiated claims of misconduct do not present a substantial basis for a petition under Chapter 211, and such petitions are properly dismissed. Unless there are any questions, therefore, because of their issues can be heard in the appeals court, I would ask for the single justice to be affirmed.
Thank you.
May it please the Court, William Bogart for United Bank. Because the petitioner's appellants made it clear that the only issue they were seeking judicial review from this court was the alleged misconduct of the presiding Superior Court judge, and not the substantive issues decided by the judge, we did not file a memorandum in opposition or an opposition memorandum brief to their motion, to their appellate brief. However, should the court have any questions about the underlying case, the status of the appeal, as an interested party, I would be pleased to take any questions the court might have.
With the status of the appeal, is it, at the moment, the appeal was dismissed as premature, right?
Correct, Your
By
Honor.
the appeals court. So where is it standing right now?
The issue was that...
Both of you have filed notices of appeal in the Superior Court, right?
That's correct, Your Honor. We filed a cross notice of appeal. The record was assembled. It was submitted. After it was submitted, the appellants stated that it was incomplete as there was a transcript that they wanted to include in the record. At that point, the appeals court dismissed the appeal to allow the record to be fully assembled.
Was it a dismissal without prejudice?
It is, Your Honor, without prejudice, and so reflected in the appellate court docket. That was more than 6 months ago, and nothing's happened. What happened subsequently to that, Your Honor, was there was a Rule 60B motion filed to vacate the judgment. There was 2 separate lawsuits filed in different courts against my client. This is one of 6 cases, 5 brought by the Mannies, 1 brought by the bank, which was this underlying declaratory judgment action to determine the appropriateness of the distribution of the surplus after the foreclosure.
Thank you.
All right, thank you very much,
Thank you, Your
counsel.
All right. Hear ye, hear ye, hear ye. All persons having anything further to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting at Boston within the court of the Commonwealth. At present departing, give your attendance at this place Thursday morning at 9 o'clock, to which time and place the sitting of this court is now adjourned. God save the Commonwealth of Massachusetts.